Welcome to The Aftermath, a podcast that rips the Band-Aid off the collective scars of divorce, custody battles, and the trauma of family drama. Kindra Reiber and Mick Smith pull back the curtain and explore stories that put the heart-wrenching puzzle pieces together with inspiring stories, notable experts, and actionable tips. Let the healing begin. Oh, welcome once again to The Aftermath. Oh, Kindra, how are you doing today?
I'm absolutely wonderful, Mick. I'm looking so forward to this episode. I know this is one that a lot of people struggle with as far as obtaining legal counsel. And so I'm so excited to get into this and dig in.
And I have been looking forward to this for so long as well. So me as well. So hope you're doing great. I'm looking forward to it, and everybody listening is too. Let me introduce our two guests because we got an attorney panel today. We have two special guests. We appreciate their time and taking some time out of their busy schedule to be with us. We have Richard A. Julius. Richard A. Julius is a senior litigation attorney or partner. He is in Pennsylvania, a state that I know and love very much. He helps people daily. He has clients, keeps them up to date and attention to detail. He looks at the process as not winners and losers, but it keeps a family interest in mind. He is intelligently aggressive. He informs people that he's working with so that they know their options, somewhat predictable, and then to help them to understand the effects of each option and the consequences of inaction and make an informed decision. So that is Richard's senior litigation partner. And then we also have Marcie Patton-Coffman. She also is a senior litigation partner. She is in Ohio, a state that Kindra knows well. She has a passion for family law. She's known for her thorough understanding of the law, the ability to communicate effectively with clients, qualities that make her a successful family law attorney. Also, very interesting that she had won temporary custody for a father that eventually resulted in full custody. So we had questions for these folks and can't wait to hear what they have to say. How do you get an attorney? How do you engage them? How are protection orders used in custody situations? How can an attorney intervene when someone takes off with the child or children? And how are court orders enforced? And these are things that we would really like to hear about and hear answers. So with that as an introduction, we have both Richard Rick he goes by and Marcie. Welcome to the program. Thank you so much for taking some time out and chatting with us today.
Thank you for having us.
Thank you, guys.
So why don't we start maybe with the first question that we had said. So it's a open question that we would really like to hear about because some of us have had some difficulties with attorneys and the people that we've had numerous attorneys. So one of the things that we would like to really get an answer to is how and what's the firm's process of an engaging attorney that will really be helpful for a potential client? How can you help us out?
Marsh, you want to
Good.
know?
Sure. Well, I think when it comes to obviously, Cordell has its own, process for retaining counsel and meeting with an initial consulting attorney who then assigns you an attorney that is best fit for you. But in switching the roles, I think when a person is looking for counsel and, they're trying to determine who that person is that is going to assist them and provide them the most benefit in their divorce, they really need to look for someone that feels right to them because it's got to be somebody that they can trust, that they can communicate with, that they really feel is going to support them and is going to fight for them and help them reach their goals. So having that, I don't want to call it kind of a bond because it's a working relationship. It should be a partnership. It should feel like a partnership with the easy flow and exchange of communication. And from my experience, as a divorce attorney, I find that different people need different things. Some people need an attorney that has you know, plays more of the therapist role, and helps them through that process. Some people need an attorney that's more of a, a, a more stern hand, that provides that guidance that helps them, through that process. And some people just need, that partner that we can work together, that we can strategize together. It really does depend on the person and what they need from my personal experience and opinion. Rick, do you have anything to add to that?
Yeah, I think those are great points. Just to kind of piggyback off of that, I always encourage people interview more than one attorney. I'm happy. I stand by my pitch, my thing that I'm telling a client in my initial consultations, and if they have other consultations set up with other law firms, with other attorneys, I encourage that. Get it scheduled, get it done, and I'm confident that they'll come back to us on that. They have to find somebody that they're comfortable with, and a lot of times we get folks that have been with other attorneys who
Mm.
didn't quite realize what they were getting themselves into because they just knew they were an attorney. And all attorneys are, built the same. They're especially in such a nuanced area of law. Some of them will be like, well, I have a friend who practices 12 different areas of law, and they said can help me on the cheap. Well, I usually tell them, think of it as a construction worker. I'd rather build on an empty plot than to tear some other guy's, you know, less than desirable structure down and have to do it all over again. So you have to be cognizant, you have to be communicative with what your goals are. And you have to, like Marcy said, get the right vibe that your attorney is somebody that, can really further that agenda and understands that agenda probably more.
If I can follow up on this, I'll say this is definitely hindsight because I was in the state of Pennsylvania and I was trying to think strategically, right? So I had 2 attorneys. One was a person who considered himself a father's rights attorney, and that didn't work out well. So then I said, well, in a lot of my ways and my situation, my living environment was more like a woman and had a very successful locally feminist attorney. So I said, all right, I'm going to try her. Well, anyway, neither one worked. So I said, by hindsight, in Pennsylvania law, is there anything that you could say that what was wrong there? What went astray? What could I have done that probably improved myself, my situation?
Well, it certainly sounds like you kind of took an approach that maybe it was a bigger cause than just your own, when you should have taken to this being your case, your life, your kids. You know, the grander battle, if it's fought, should always be secondary to what's important to you. So it probably wasn't the best decision to say, I need somebody that specializes in, my role in this greater cause or my perspective in this greater cause. I need somebody that understands where I'm coming from, my roles, my family's roles in all of this so that they can best navigate the strategy for me.
Yeah. And to kind of think, like, to double up on that, it's a matter of mindset, you know, like you had said before about, you know, Rick indicating that it's not winning or losing. You almost
Mm.
need to look at it as it's an investment in your future, right? Because you're closing one door and you're opening another, and you want to make sure that when you open that other door, you can move forward as smoothly as possible. So trying to approach it with the correct mindset on moving forward, I think also helps and assists you in obtaining the right counsel for you.
Yeah, I think divorce and custody are hard enough alone, let alone the idea of shouldering some, greater cause, greater burden, of someone else or some other group of people on your backs. It just needs to be something that, works out for you and then hopefully spreads to other people by getting you the good results that you need, not, furthering some cause.
That's great feedback. Several takeaways that I had from that is we want to interview a few, Rick said. We want to maybe figure out which person bonds with us best, Marcy said. So whether it's, we need a therapist or we need somebody with a firm hand. And, just to follow that up is think about yourself because I think that's something that we kind of lose. At least in my situation, I was thinking about the children and I didn't think about my future. And that was something that can learn from.
Yeah, I always think about the warnings on an airplane before you take off. It's like put your
Yep.
mask on first before you help others, and
Sure.
make sure you're taken care of. Especially in roles when there's custody there. If you're not taking care of yourself, you're not going to be in a good position to be able to take care of your kids, and that is especially for litigation. So.
Mm.
Yeah.
Definitely.
Well, great. Well, let's move on to the next question. How are protection orders used in a custody case. And the reason that Mick and I asked this question is because Joe had brought up to us that protection orders can be used as weapons. And maybe we're asking you guys to elaborate a little bit further on that because protection orders seem to be so commonly used in custody cases. So, what do you see and how do you approach that as an attorney? I guess depending on either what side it's on, right? For your client or, against your client or your client's using that, I guess.
I think that it's first really important to acknowledge that protection order are necessary. There are certain situations in which they're 100% necessary and they're a necessary tool that people need. Now, unfortunately, there are circumstances when they get used, to get one up on a custody case or, whatever, to manipulate the situation. And that makes our jobs twice as hard because there's never going to be when you when you think of the judiciary, you think of judges, you think of magistrates as they're making the decision. None of them want to be the person that got it wrong, right? None of them want to be the person that says, you know what, I'm not going to issue a temporary protection order or a domestic violence civil protection order because this case is too weak. And then have something come back, some horrible event come back, 2 weeks later, 3 weeks later, and they find out they're wrong. They're always tend, for the most part anyway, to err on the side of caution. But that often opens up a chance or an opportunity for people to manipulate and to use them inappropriately, to get up on custody, to get somebody kicked out of the house, to, I hate to say manipulate the system, but I don't have another word for it, so to speak. But when that happens, it makes everything twice as hard because now the parties can't communicate because there's a protection order in place saying that there's no contact. Often parties can't see their kids, even if their kids aren't a part of the protection order. And it's just a spouse that has been protected by them, but that spouse also has the children in their possession. And since they can't be within, so many feet of that spouse, 100 feet of that spouse, whatever the circumstances may be, now they can't see their kids either. And often it takes a long amount of time to remedy these things. So one parent may end up going a significant amount of time without seeing their kids. And that can just almost start a whole domino effect because you're dealing with a domestic violence civil protection order case that's not going to go into your divorce action, which is going to impact your parenting time and your temporary parenting time orders under that divorce action. I thought I'd give you talk, Rick.
No, it's all good. No, I really think that particularly in the post-COVID era, we're seeing a lot of that sort of weaponization of protective orders. I think we're in the middle of a societal kind of course correct to the idea of domestic violence and, with social justice campaigns and that sort of thing. We're starting to see a lot more legislation to actually make, PFAs, as they call them in Pennsylvania, more powerful. So, just to kind of expound on what that looks like in Pennsylvania is all it takes is an allegation that rises to the level and a light most favorable to the party claiming abuse to get a temporary order. That happens at a hearing that's what they call ex parte. And the other side's not even invited. You could know about it. You could be sitting in the hallway of the courthouse and you won't even be invited into the room to defend yourself in that hearing. So you're effectively, if the person alleging the abuse even rises to that very small standard, they're going to have you kicked out of the house and probably not seeing your kids for roughly 2 weeks at a minimum. And then you end up at what we call a cattle call for final hearings where there might be 50 hearings scheduled all at the same day at the same time. And you're hoping to get enough time to be able to talk a judge into hearing a case, in its entirety in order to defend your client. There's so much at stake in all of that now what we're seeing is it's becoming even more weaponized in the backlogs that exist in the court post-COVID. It's, if we file a custody action now, we know that there's a pretty good likelihood that we're not going to see a custody trial inside of a year. And so whatever is going on until that custody trial is going to control a huge part of those kids' lives, a huge part of those parties' lives. And so people are feeling tempted to, dare I say, abuse the abuse system and bring these claims that might be exaggerated, bring these claims that might just be patent false, because the alternative is this untenable situation where they feel as if they can't get in court for an extended period of time. And we have backlogs that are even longer than those ones are. So when we talk about how it's sort of weaponized, it's weaponized because we've created a system that allows it to be weaponized. And we're actually, in Pennsylvania, there's legislation pending to try and further weaponize it to the point of wanting to add house arrest as a provision for what is a civil order. These are civil protection orders. You don't have a right to counsel. You don't have Miranda rights. You don't have any basic criminal rights, habeas corpus or otherwise, unless and until it's violated. So at that point in time, you're utterly defenseless, but you're also subject to criminal law as a part of it. A lot of people don't understand that when they're on the defensive side. Most counties in Pennsylvania have mechanisms in place where plaintiffs get free counsel and have zero mechanism for defendants to have counsel. So we start to see things, economic inequities where, one party gets a free attorney, the other party can't hire an attorney, but needs an attorney, or otherwise they're making decisions that are impacting their family when they're literally up against a wall. So from the weaponization standpoint, I absolutely think that it's a problem out there. I don't know what the fix to it is. I caution my clients against it every time I meet with them to try to stay out of it and play defense and make sure that they're not subject to it. But it happens every day. And, not to discount the fact that it's there for a purpose. But what I'm seeing is there seem to be a lot more that don't have that purpose of true protection and are more a litigation strategy.
That is so very sad. Thank you both for sharing. I have been subject to the protection order filed and then not seeing the kids or having any contact for 7 months, which led to the ultimate decision from the GAL that I didn't have a good enough relationship to have full custody. So I am in that position. Typically, I know you guys represent men. Typically, that's happened to a lot of the men. We are now seeing happen to women across the board as well. So it is being used on both sides. And unfortunately, we've gotten away from actually using the protection orders the way they need to be used in those situations, Marcie, where they actually are needed, right? Now it's just another piece in the chess game. And
And
that's
it
very
just
sad.
and it is, I mean, it's incredibly standard, and it's a snowball because you're essentially setting a standard, right? You're setting okay, this parent can't see the kids. And if it goes on for that long, 3 months, 6 months, it completely changes the dynamic. So now we're also probably facing additional costs. We're
Mhm.
probably facing some kind of reunification therapy, counseling, maybe supervised visitation that you have to pay for somebody else if you don't have a center available, which individual, supervised visitation is much more expensive than a center, but either way, you have to pay for it. So you know, it's a snowball effect.
Mhm.
That even if you are cleared on every single thing, it still impacts the whole parenting dynamic because the courts are still going to base it on the best interest of the children. And if over that 6 month period, the children are now concerned or scared or whatever, this court's still going to hesitate to, have unsupervised parenting time or no overnights or whatever, because they want to make sure the children are comfortable, despite it not being the other parent's fault, despite the parent not doing anything. It's just the circumstances. And at the end of the day, the court is always going to look at what is best for the particular children involved.
Correct. Yes, I agree 100%. And to expand on that, you now have a psychological problem with the children because of that time period. Like you said, they might now be scared where they weren't before. Now all of a sudden it's like, oh, wait a second. I haven't seen mom or dad in 6 or 7 or 9 months. And, I've been told all these things. And so now I think I'm afraid of my parent when I wasn't before, but I think I might be. And you make them doubt. And so if you don't have the right counselor, or therapist or whatever might be working with the kids that are recognizing these issues, you have an even larger problem that the courts will never be able to solve.
And that's its own backlog too, Kendra, because it's so difficult to get appointments, especially with folks who aren't already installed with mental health treatment in their lives. You can't get an appointment at a lot of folks, especially if they know that there's a custody litigation involved, or it might, consume more time, where they might be, taking up the space of two patients with your one case, where they're backing it up months and months to get even an initial appointment to try to start remedying those situations. It just kind of works in that snowball effect, like Marcie said, that the delay has caused this issue. And then it doesn't matter why they're afraid. It matters that they're afraid. And the further that draws out, and the more afraid they're going to get. And so it just keeps perpetuating itself.
Yeah. And Rick, I wanted to come back and touch on something you had said, and I'm very surprised that Pennsylvania is going the opposite way than surrounding states, which is Kentucky and Arkansas. And right now, Ohio is looking to propose and pass a bill that would be they need clear and concise evidence, clear and convincing evidence versus a preponderance of evidence. So when they file these protection orders and it goes through, they have to have clear and convincing evidence, not just a preponderance. And there's recourse for false allegations.
I,
So,
I've, I've never once seen a punishment for false allegations, and I've litigated a lot of these, and I understand why. And I've heard the words chilling effect, or we don't want to dissuade folks from coming forward, and that sort of thing as a reason. We're not going to punish this person in front of us, even though we've basically proven that they've lied or misstated things in their petition, because we don't want somebody who really is being abused, to
sure.
refrain from coming forward. But right now, I think that's part of the reason why it's gotten out, in that there is, the worst punishment for getting caught with your hand in the cookie jar is that you're going to have to put the cookie back. And if that's the case, then why wouldn't these folks try this?
Hmm. Yeah. I think when you have the law changed that you have to have clear and convincing evidence, then it is a little harder for somebody to come forward with false allegations. So they're not going to be as apt to do it. And so we're actually going to get to those serious cases where there is child abuse or domestic abuse that needs addressed. And when you look into Kentucky, they have about a 50% reduction in those false allegations that were presented in custody cases. They're not in court all the time fighting these. So you're actually getting the real cases. And I think that is where Kentucky has excelled. Sweden also has a 50-50 shared parenting that works really well for them from the time that they separate. So they don't have anybody in court kind of fighting these battles out. Or attorneys like you can actually go in and work on the real cases. And that concludes part one with our legal panel, Rick and Marcie from Cordell and Cordell Associates.
We had a great part one session, did we not?
We had an absolute wonderful session with them, really asking just a few questions, but I'm really looking forward to having them again.
So stay tuned for part two. That'll be coming soon. We also want to put a plug for sponsors if anybody's interested, because we've got a whole range of things that we'd really like to have on the Aftermath podcast: Facebook ads, magazine promo, YouTube promos. And as we've grown, we also have some administrative tasks as well. So if you know anybody's interested in sponsorship, we'd love to have that as well. And you can contact us at the Aftermath Healing at gmail.com. Now, if you're listening, please listen, like, share, subscribe, and positively review. And before I forget, we don't have it handy, but don't we have a download that people are interested, possibly, Kendra?
We do. And I think it actually is a great follow up to what we were just talking about with Marcie and Rick. And that is about protection orders and different things. And I think actually it's written by the jailbird and the juvenile delinquent, but I'm not
No,
sure
way.
who's who.
I don't know either, but I think if you get the download, you'll figure that out, and you'll want to make sure that you're staying for part two as well, because that's coming soon. So until next time, thanks for listening in and supporting the Aftermath podcast. Until next time, day is full.